to answer a question on impact of human rights in context of statutory interpretation. There are three elements of how the question should be addressed. Number one, what are the rule approaches of statutory interpretation? Number two, how does the human rights 1998 affect these approaches to interpretation of statutes? Number three, does this constitute a fundamental change to the rule or approaches? Number one, the fundamental purpose of interpretation is to give effect to Parliament's intention. There are no strict rules that judges must follow. Historically, the judiciary have adopted a variety of approaches. Briefly discuss with examples. Discuss development of the purposive approach with examples. Examples being the case law. Number two, how does the Human Rights Act affect interpretation? Describe the operation of Section 3, Section 1 and Section 4 of the HRA. Describe the approach taken by the judiciary to Section 3 and 4 using examples. A Section 4 declaration of incompatibility is viewed as a last resort. Straining interpretation, R versus A, leading down, A down versus Mendoza. Reluctance where it is a controversial area of law, A.G. Nicholson. Examples of declaration of incompatibility, for example, A versus Secretary of State for the Home Department. Number three, is this a fundamental change? Judges continue to adopt a literal and purposive approach to interpretation. They also continue to use traditional aids in seeking to give effect to Parliament's intention. The HRA does not radically change that, but there are many ways in which the ECHR changes the approach and the balance between the judiciary and the legislature. Straining to avoid a declaration of incompatibility means judges going further in reading in and reading out words in statutory provisions. Does this occasionally mean that they are in fact doing violence to the intention of the Parliament? While this doesn't produce a fundamental change to the rules of statutory interpretation, the emphasis on finding a way of reading provisions as compatible with the ECHR has led to a difference in approach, e.g. Feldman 2005, and a subtle shift in the relations between